SJC-12736, Janice Magliacane v. City of Gardner.
Watch your step.
I'm just going to wait till.
Well, I mean, it's just so it doesn't work.
Okay, folks can quiet down. Ms. Blauner,
Good morning.
we're not leaving. We're not leaving.
Good morning, Your Honor, and good morning to the community of Barnstable. I represent the plaintiff, Janice Magliacane, who is a resident of the city of Gardner. Ms. Magliacane brought suit on behalf of herself and other residents whose copper heating coils have failed as a result of the city's alleged negligence in connection with the sale of corrosive water. It is the plaintiff's position that the Superior Court has erroneously dismissed the plaintiff's case for failing to make timely presentment of her claim under the Massachusetts Tort Claims Act for two reasons. First, the Massachusetts Tort Claims Act does not apply, whereas here the city of Gardner was engaging in commerce and not in a governmental function pursuant to the act. And even if the act...
Why is it commerce to, I mean, providing water is something we think of as kind of a municipal function, don't we? I always, I mean, it doesn't seem like, it's not like they're selling Coca-Cola, right?
Well, Your Honor, in the Harvard Furniture case and the DePrado case, this SJC held that the sale of water was engaging in commerce rather than in performing a government function. And
Those are pre-Tort Claim Act cases, right?
it is a pre-tort, that is correct, but in terms
What are
of,
the dates of those cases? I mean,
those cases date from the 1950s, I believe. And there's also the Gantz Tire case, the Massachusetts Appeals Court, 16 Mass Ave from the 1980s, which was post-Tort Claims Act. And the trial court here held that the sale of water was an action in commerce and not a governmental action. And the question is, of course, whether it can be, whether it is something that private companies can do. And in fact, in this case, the city used a private company to help it sell the water to the citizens of the city of Gardner.
We probably have a lot of questions on that, but can you get to your second, what was your second point, if you can just state it?
Oh, our second point is that even if the Tort Claims Act did apply, that the plaintiff, Janice Magliacane, did make timely presentment, and that the Superior Court here truly both engaged in fact-finding and misread the complaint and the allegations in the complaint as to what was public at what point in time. In fact, even after September of 2015, the city of Gardner, including the mayor, including the city engineer, at public hearings, all said that this was a natural occurrence, and the city had no role in the causing the corrosive water, which is the allegation in the complaint. So our view is that even if the Tort Claims Act did apply, that the claim was timely, and the court engaged in improper fact-finding when she ruled to the contrary.
And is that because there was not notice sufficient to start the clock, or because there was fraudulent concealment and failing to say that, well, the problem is caused in part by our failure to add the orthophosphate, and also the fact that we did add chloramine?
It is both, Your Honor.
Okay, so
There wasn't.
you're alleging both.
We're alleging, and there's a third reason, that the tort was continuing after September of 2015, and this court has held on more than one occasion that in the context of a continuing tort, that presentment is told.
And when did she replace her coils?
She replaced her coils between 2012 and 2015. But the issue from a statute of limitations point of view is not when she replaced her coils, but when was she on sufficient notice to know or should have known that the city's conduct caused the failure. Not that it was negligent, but the city's conduct caused the failure. And our argument is that she was not on notice in September of 2015 that the city's conduct caused the coil failures.
So she was on notice that they admitted that water was the cause, but said it was simply because we have low alkaline water.
Yeah, I mean, they expressly stated in the press release that it was a natural cause and not, and in fact, they expressly said it has nothing to do with the additives to the water. So she wasn't on notice at that time of the city's conduct.
Well, is there an issue with regard to the absence of an additive?
There's an issue, there are two issues. One with respect to an additive, which was chloramine, which they added to the water, as well as the failure to implement its pre-existing plan, which was approved by the Massachusetts Department of Environmental Protection to add orthophosphate. And the city's actions, it's both of those issues.
Those discretionary functions?
They are not discretionary functions because the issue of discretionary function is the distinction between policymaking and implementation of a plan. Excuse me, Your Honor. Here, the plan was in place and they didn't follow the plan. And so this is not an issue of discretionary function. This is an issue of the failure to implement an existing plan that in fact had been approved by the Department of Environmental Protection.
Then as to that, I gather from the briefs that the plan was that they got DEP to approve the orthophosphate. Was there any DEP approval or discussion about using chloramine as opposed to chlorine?
I do not know the answer to that question, Your Honor. But we know that the DEP has to, I don't know the answer to that question.
And I mean, is there anywhere in the briefs on the record that answer would be provided?
I do not believe so, Your Honor.
So is this the first time we've dealt with a class, with the issue of how to present on behalf of a class?
This is the court has never, the SJC or any Massachusetts court has never addressed the issue of how to do presentment on behalf of a class. There are numerous decisions in other states which have similar Tort Claims Act, which have held that where a claimant is making a claim on behalf of class and specifies exactly what the nature of the claim and on whose behalf they are making the claim, that there doesn't have to be individual presentment by each member of the class. But that would be a completely novel issue for this court. However, I would note to you that the SJC has addressed in a Chapter 93A context, which is slightly different, that a demand letter made by an individual on behalf of a class is sufficient to be demand on behalf of the class for 93A purposes. And I would suggest that line of reasoning would apply here.
Is there?
Okay.
That's good.
Please.
Go.
If we just take a step back for a moment and see whether the Mass Torts Claims Act actually applies if we're dealing with a propriety or a commercial function in selling water.
Sure, Your Honor.
And we have in mind the legislation in 1992, I think it was, with the water and sewer being able to be addressed by municipalities. But if we could just think about it for a moment, when sovereign immunity is abrogated, isn't the whole point, I realize Justice Spina's Superior Court case, but isn't the whole point when the Mass Tort Claims Act comes in and we've got the sovereign immunity that we don't have that distinction anymore between commercial and public?
Your Honor, the statute itself is silent on that question. There are certainly many statutes of Tort Claims Acts around the country which actually expressly abrogate the distinction between between proprietary and governmental functions. The Massachusetts statute doesn't say that, and it's different from the situation in Morrissey, where the statute, and the reason that one of the linchpins on which the court rests its holding. In Morrissey, the statute said negligence or other wrongful conduct, and so the question is whether it extended to a nuisance claim. So the issue about proprietary versus governmental has never been addressed by this court in any depth, other than on a very brief footnote in a case which didn't involve this issue. I would argue that, particularly if you look at the court's decision in the Woodward School for Girls case versus Quincy, in that case, the court noted, and this is a post-Morrissey case, that the policy purposes of sovereign immunity are not served where municipality takes on a responsibility beyond its inherent and core governmental functions, and therefore serves in a capacity that could just as easily been accomplished by a non-governmental entity. So the act itself was really about creating a uniform set of rules with respect to governmental functions.
But it has the same effect on the population of the town that's going to have to pick up this, verdict, right? I mean,
I'm sorry, I couldn't.
if it's the governmental proprietary distinction, the impact on the town and how they're going to pay the judgment is the same, whether we're in governmental or proprietary, right? I understand you can draw this sort of distinction, although the cases have said it's kind of arbitrary and the lines are all over the place. But the impact on the town, you get a massive verdict here. The town's going to have to pay it. The citizens of the town are going to somehow have to deal with that. Doesn't that make a difference?
Well, I mean, the town has insurance to cover these claims, so this is not, it's not coming out of the town's coffers in that sense. I would say that you can look at it in a couple of ways. Certainly, if there's money is money, and so if the town has to pay money or their insurance carrier has to pay money, they have to pay money. But you have to look at it also in the sense of, what if a town decided it wanted to open a gym, okay? And the town wants to open a gym. There's Equinox next door. There's another gym there, and it's a purely commercial matter. Why should the town have the benefits of the protections of the Massachusetts Tort Claims Act when we're talking about a purely commercial function that the private gym next door does not have the effect of? So if the town opens the gym, the town...
They're not in the profit-making business. They're in supporting the town-making business.
Well, our claim is that they were making profits off of this.
To pay for other municipal functions, right?
Well, it's always paying for something. That is true. I mean,
Can I shift you back to the class action one? Because I'm really confused by what standard we're going to propose here. So if we allow a class to be certified, I understand in this case that may not be that complicated because the water is going to probably affect everybody in a sort of common way. But are you asking us to draw a rule that every class action is going to provide presentment for everyone in the class, even when there are all different kinds of injuries that can be covered by a class? Isn't that going to wipe out the purpose of presentment, which is to alert the town of the individual facts as well as the theories that are being presented?
well, I think that's not true, and I mean, like I said, this court has ruled in the 93A context that the presentment by an individual class member is sufficient to be presentment on behalf of a class. I mean, that's a demand letter, but it's the same idea. And I think you have the protections of the class action mechanism here. And so
we have municipal finances and government in play, not just, 93A is the private sector. We may be more tolerant there than we're talking about government.
Well, I think first of all, there are many other states that have looked at this issue and have held that, that presentment by an individual on behalf of a class.
And do they have more nuanced rules, or is it just if one person presents in any kind of class action, everybody's covered?
Well, I think-
Or is there some kind of more thoughtful approach to that?
Well, I think you have to look at the nature of the demand letter, okay? And you can look at,
Is that what those cases say, that it depends on the quality of the demand letter, or what?
I think presentment always depends in to some degree on the quality of the demand letter and
Although
whether.
we have those presentment cases, even in individual cases, are often not detailed enough. So now we're going to have a presentment in a class action case. I'm just trying to understand the standards we're going to impose there.
Well, I think the answer is, the question is whether the demand letter put the city on sufficient notice that it was able to investigate and respond to the demand. And the record here is it was. The demand was made, the allegations are very specific in the demand letter. As Your Honor pointed out, the issue for all of the people in a case like this is the same. The water is the water, and so the issue is the same for everyone who had purchased this water, and the city responded to it by saying, we don't think we have any liability here for anyone. So there wasn't really an issue here about whether it was 1 versus 100. So I think that if you look at the specific demand letter here in response, I think that it is clearly sufficient to put the city on notice of the allegations such that it could investigate and properly respond, which it did.
But the issue before us is not whether to certify your class. The issue is only whether or not to allow a decision to be made as to whether it should be certified.
Of course, Your Honor, the certification is going to depend on the record that is presented to the court in terms of the class, and it will be decided at that time. But I do.
The position, though, is that you don't even need a presentment letter in this situation. That's your first position, isn't it?
Our first position here is that the Massachusetts Tort Claims Act does not apply.
For the commercial and proprietary.
Correct, and that.
And then if there is a presentment, of course, the issue is whether you did it on time. And we've got a big dispute as to that. I mean,
Well, I think
in 2012, there's 250 complaints. There's all sorts of things that are happening before October of 2015.
There were, and the city said it was because of the problem with the coils. I mean, they said it was the manufacturer's problem. That's what the city was telling the residents, that the problem was the coils. And then in September of 2015, when they get this report, they misrepresent what the report says. And they said that it was just a problem with the natural state of the water and not the additives. That's an affirmative misrepresentation by the city. If you read the report said that the addition of chloramines here was a problem. And so what is a resident of a city to do? She did what she was supposed to do. She continued to investigate. And she went and she investigated and got information from the Mass DOP till she finally found out that this problem was caused by the fact that they were adding chloramines and hadn't added the orthophosphate, which had been approved by the Mass DEP. I think it is the court really did engage in very improper fact-finding on the issue of the statute of limitations, given the allegations in the complaint. And so, like I said, there were 3 reasons why the court erred on that point. It is because she didn't know or should have known in September of 2015. B, the city continued to fraudulently conceal that its conduct contributed to the coil failures. And D, because there was continuing wrongdoing by the city by continuing to engage in the conduct that it had engaged in before. And the SJC decision in, I can't, have the name of the case, but the SJC has expressly held that in areas of continuing tort, there is no presentment required till the tort is over. And we're saying that it wasn't over by the time that she filed her complaint. So, I mean, the SJC's decision on that couldn't be any clearer. On the issue, I don't know if you have any, I know we spent a lot of
Afraid you're-
time on some of these other issues.
I'm afraid your time is up. But I've got one last question. There are many exclusions in the Mass Tort Claims Act. I don't recall there being any exclusion against class actions. Is there any exclusion against class
There
actions?
is no exclusion in the Mass Tort Claims Act against class actions. And in fact, it says the remedies that are otherwise available that you would have against a commercial actor are available against the city, subject to the other exclusions in the act.
All right, thank you.
Thank you, Your Honor.
Mr. Davis.
Good morning, may it please the court. John Davis on behalf of the city of Gardner. A couple of quick points. The plaintiff did file a petition for certification as a class action, and that was denied by the judge. And it went to the single justice, and that was denied. That's not on appeal here. This is the appeal by Mrs. Magliacane of her case for the damage to her water heater.
So we don't have to decide the class action?
No, you do not, Your Honor. You do not. That's really not an issue in Ms. Magliacane's case. Prior to the adoption of the Tort Claims Act in 1978, the distribution of water was considered proprietary, and for which a city or town or municipality could be held liable, unless the water was used for the suppression of fire, in which case it was governmental, and for which they were immune. Prior to the adoption of the Tort Claims Act, the collection of rubbish or refuse was considered governmental, unless they collected a fee, and then it could be considered proprietary, unless the fee was considered insignificant in compared to the total cost of the operation, in which case it went back to
Are there
governmental.
any implications for that analysis or that distinction based on Article 97 of the Constitution, the right to the citizens to have clean water? I mean, does that bear in this at all or not?
I think it does, Your Honor, in the sense that if there is a distinction between proprietary and governmental, which we maintain there is not, we would maintain as our second argument that even if there is that distinction, the distribution of water is governmental. The distribution of water is where the old cases that talked about services that were providing and charging, and then the city for water to most people had wells, and certain companies began to provide water, and then government started providing water, and they would assess a charge as well. Those times are gone. I think we'd be applying 19th century notions to a service that is almost quintessential to the nature of government today. And I would rely upon the amicus briefs along those lines.
That's the 1992 legislation that the town of Westwood
Yes, Your
talks
Honor.
about?
Yes, the model water and sewer reorganization act. And at that time, the legislature said that a government can create sewer and water commissions. And their only business, water and sewer commissions, water is the distribution and treatment of water. Sewer is the collection and treatment of wastewater. And then at the same time the court did that, the general court did that, they amended Section 1 of Chapter 258 to make it clear that water and sewer commissions going forward would be considered public employers for purposes of the application of the Tort Claims Act. So I'm sorry.
I'm sorry, so assuming you're right that, Gardner, that this whole issue falls under the Mass Tort Claims Act.
Yes.
What do you do with the fact that Gardner was saying, hey, it's not us, it's the coils, it's this, it's that, it's the other thing?
I think the record reflects that there were studies conducted, and including one by the DEP back before 2015, and then that were inconclusive. And then there was a study conducted in 2015, and the plaintiff cites that study of September 2015, and the plaintiff cites, and that appears at paragraph 43 of the plaintiff's complaint at Appendix A21, and at paragraph 60 of plaintiff's complaint at A25, the plaintiff cites the press release by the city, where the city says it's the water. The city doesn't say it's our fault. The city says there's a natural condition in the water,
isn't
but the
isn't
water
that-
is the cause.
But
It's
isn't
no
that,
longer.
but isn't that obfuscating that you're at fault? By saying there's a natural condition when actually there's something we should be doing that we're not. That's what that study recommends, right? Isn't that too clever to say they're on notice? You know,
Especially with Microvision's finding.
Right. To the extent that whether they're on notice, it has to be something inherently unknowable. For the Krasner-Allen case, to say that the discovery does not run. And I would maintain that when they notified the public that the water was the cause, and they also suggested at the same time that the possible solution for that is to change the chemistry of the water. So in September of 2015, the public, including Ms. Magliacane, is on notice that it's the water and it's the water chemistry, and we're going to look into ways of potentially changing the water chemistry.
Okay, would your argument be different if this were not copper coils, but water quality that was affecting the health? If this were not Gardner, but Flint? I mean, I mean, people just drink water, okay? I mean, what you're asking them to do is to conduct an investigation when the city says this is high alkaline water. It's nothing we did. No reference to the fact that, oh, there actually was a fix of orthophosphate, which DEP approved, which we didn't do. No reference to the fact that chloramine was added, which appeared to aggravate the problem. If we were speaking about public health as opposed to copper coils, would you still be making the same argument?
Well, I think, Your Honor, with respect to the public health, and yes, they're adding chloramine, which is to kill germs, which almost every community adds some sort of nature of a chlorine product. And the issue here was the alleged failure to add orthophosphates, which would reduce the corrosive ability. The city was presented with an issue of what to do, so they have clean and healthy drinking water. So it's not a Flint case.
I understand, but you're missing the point. The point is that the legal standard that you're imposing would apply even if the issue were public health as opposed to copper coils.
No, and I think, Your Honor, that
Are you saying it's different? Or are you saying that if the claim here was not that we had to replace copper coils, but that my child was getting very sick from the water, that we'd be in a different world in terms of what the standard would be with regard to presentment?
No, I think once somebody is on notice, Judge, once something is not inherently
So you're
unknowable,
saying that
I would agree.
if the issue were that the water is making my child sick, and the city says a press release that says, well, the water is naturally what it is, and there's nothing we did that would possibly affect that would mean that parent would be on adequate notice to conduct an inquiry to say, no, actually, it turns out that there were things the city either could have done or in fact was doing, which was making her child sick.
I think at that point in time, Your Honor, if somebody believes that their child is being made sick by the water, and there's more information than just one person coming forward and saying my child is being made sick by the water, and that's in their own, the allegations of their own complaint. But I think the question is, whether is it inherently unknowable for the next 2 years that there was no connection between the condition of the water and my child's health. And that's the issue here. They waited for 1 month too long.
Okay, but does it matter that the fact that you actually had information which you withheld, which is that there was a fix, which was the orthophosphate, which DEP had approved and you had decided not to use?
That information was out there by September of 2015. And that the DEP study predated the CLT study.
But back in 2012, you know there needs to be, what is it, a phosphate corrosive inhibitor or something like that? Is the plaintiff supposed to know that?
Not necessarily, Judge, but at that time, you raised earlier, when my sister was arguing, the issue of the discretionary function exception. And the city is wrestling with the issue of what do we add another chemical to what is clean and safe drinking water? And do we add another chemical to clean and safe drinking water because some people are saying they're having accelerated corrosion in their appliances. That was the issue that the city was wrestling with. So that's why they conducted the studies. And then
Well, is it factual, though, whether it's discretionary or an implementation of a policy?
Well,
Is that a factual question or not?
No, you're right. Unless they can show that there are standards and guidelines that we were required to follow, and which they did not show to the Superior Court, that there were standards and guidelines that we didn't follow, then we were exercising our discretion. And then the question, whether is it the type of discretion, you use in the two-pronged analysis, is it the type of discretion for which a public employer should get the benefit of the statute? And we would argue it is, because they're wrestling with, again, adding chemicals to water. And second of all, the downstream effect of adding chemicals to the water was a potential algae blooms in the wastewater treatment.
I appreciate all those arguments. I'm just wondering whether it's a discretionary function or not in the context of this case. Is it a factual question or a legal question?
I think based upon this was a motion to dismiss.
Right.
So based upon the allegations in the complaint, the judge was entitled to find that the discretionary function applied.
How? I mean, going back to Justice Lowy's question, how was the judge, based on the allegation of the complaint, going to be able to say that it indeed was a discretionary function as opposed to what the plaintiff alleges, which was that a decision had been made but not been implemented? That's what she says happened, that there was a decision made, you didn't do it.
Based upon the allegations of the complaint, Your Honor, I'm not sure that those are the allegations of the complaint. My understanding from the reading of the complaint was that studies were being conducted and there had been no determination or instructions by the DEP. Whether or not the DEP approved the addition of orthophosphates is different from the DEP ordering us to implement a treatment plan that would include the addition of orthophosphates to the local water.
Okay, so you expect in a complaint that the person is going to be presenting facts that is going to demonstrate that it's not a discretionary function? Isn't that a summary judgment issue to be addressed after discovery?
It may be a summary judgment issue at times, Judge.
So
I would say
if that's the case, then you should not prevail on a motion to dismiss on those grounds. It should be left.
If that is a factual question, yes, Your Honor, we should not prevail on the discretionary function exception. We maintain that we would prevail still on the presentment issue, and we would maintain that we prevail on 10J, because the issue here is the condition. This is the condition of the water. There's no doubt that it's the condition of the water that the plaintiff is complaining about. 10J protects the city or town.
It's water that you're treating or not treating.
Not treating is an omission, Judge. An omission, a failure to treat.
So you're saying that in Flint, the failure to, if they simply didn't put in a chemical that would preserve public health, that's an omission, and therefore that's okay? That's within their, that's immune from?
If the condition is water, safe drinking water, and the omission is the failure of a city or town to add a chemical to safe drinking water.
Right.
So that it's not going to accelerate the corrosion of heating coils.
Right.
I would maintain that the public employer is protected under 10J.
So in that case, then the failure, essentially the failure of a city or town to treat water at all and simply allow whatever water is in the reservoir to go straight to people's faucets means that the town can't be held liable for the failure to treat it to ensure its safety?
I would disagree, Judge. We're bound by their state standards, their federal safe drinking water standards.
Okay, but I'm not referring to state standards. I'm referring to what your claim under 10J. You say, oh, that's an omission, and therefore under 10J, we can't be held liable for the failure to add something to the water. Is that your position?
My position is, Your Honor, if the failure to add something to the water is an omission, this court and the appeals court has said that an omission cannot be an original cause for purposes of the exception to the 10J immunity.
So your position then is that a water authority can never be held liable under the Tort Claims Act for the failure to add something to the water which would make it healthy, whose omission would make it unhealthy? Is that your position?
Under 10J, yes, Your Honor.
But it can't be. It can't be, because if there's a low level of pH level in the water and you don't do anything, maybe that's 10J. But if.
Oh, there are other ways we can be held liable,
But
Judge.
it can't be that you don't have to do anything because you didn't cause the water that's making kids sick. There has to be a distinction available in there.
Yeah, I agree, we're obliged to provide safe and clean drinking water. I'm not
If you didn't cause it,
trying
you
to
still
distance
got-
myself, and I'm not trying to compare myself to Flint either.
Okay, because you can't just say, well, it's not safe, but we municipality aren't gonna do anything. That
No,
can't be right.
and I don't think we're entitled to provide an unsafe product to the community.
Okay,
I'm not saying
But the
that.
issue is not whether you're entitled to, the issue is whether you can be held liable for failing to do so. Do you say you can be held liable for failing to do so?
I say that, and under the decisions of this court, Your Honor, I don't, if the failure to do so is an omission, and an omission is not an affirmative act, and an affirmative act is not an original cause, I don't know how you get around that.
Okay, so then you're saying that there's basically no remedy for somebody who is drinking unhealthy water to sue the city for failing to make the water healthy, because that's an omission.
I think at some point, Judge, when the issue comes to a city or town, and then it is brought to their attention that you need to do something about the drinking water, I would understand that the city or town must react and respond to that, and they could be held liable for their failure to do so. I'm not quarreling with you on that.
I think you are, actually, but I've lost you a little bit there. I mean, I understand there may be some political imperative after the fact, but I'm saying if, I'll try to phrase it as clearly as I can, if a city fails to add something to a water system, and as a result of that failure to add, the water is unhealthy and is making people sick, do those people who are sick have any remedy against the city under the Tort Claims Act, or do you view that because of 10J, because it is an omission, that they are protected from liability?
I don't know how you get around the 10J.
Well, you have to, because
Yeah,
it can't be. It's just, you'd have to say that it's a.
Right.
you'd have to say-
I follow you.
You
Yeah,
have to say
right.
it's an original cause, that the water.
You would have to say it's an original
You'd have to
cause.
say it's an original cause. It
You'd have
can't
to
be.
say that omission is somehow an original cause.
Yeah.
Because it would, if we originally cause it by putting it in the pipes, we originally cause it by the way we treat it, by not, and we add the wrong chemicals, we originally caused it. We would have to find a way to do that, Judge, but I'm just saying that under the traditional analysis, the failure, an omission is not an affirmative act. That's what I'm saying.
Okay, thank you.
Thank you.
Thank you, Your Honor.